the High Court to decide within a period of 6 weeks or all the way proceedings. Until then, status quo shall maintain. So that's what we are saying.
Yes, I'm sorry. I thought your lordships are saying
the difficulty here is that the lawyers don't permit even the judges to open their mouth and start responding.
I just wanted to point out, Lord, this is a consent order. He takes benefit of the order, then challenges it. Gets a status quo.
No, not a consent order.
It's not a consent order.
No, not at all. It's a direction. It's a direction of the court. It's not a consent order. And Lordship, I'll show the relevant.
It's directed. Where is consent of the party? Where is consent of the party?
No, after interacting with the parties.
Very good. We find that since the present proceedings, right, on a specific query as to whether the children are studying are with the father or with the mother, it is informed by both the sides that the petitioners are with the father and studying at Bangalore and presently studying at Bangalore. Since the present proceedings arise purely out of an interlocutory order passed by the High Court dated 8th of April 2024, we direct that the High Court shall decide the contempt petition as well as the writ petition for its writs as early as possible and preferably within a period of 6 weeks.
If I may just
permit us to dictate, or you start dictating the order? Yes, dictation. Till the High Court decides the matter on court's merit, the status quo, as was directed by this court, by order dated so and so, 10th of May 2024, shall continue to operate. Yes, now please tell us.
Lordship, I was only saying that the guardianship proceeding, there is a transfer petition which has been pending. It has been stayed. And the fact of the matter is because the High Court order is very interlocutory, and the order which has been passed, the status quo can be maintained till the pendency of the guardianship proceedings.
No.
That's okay.
Yes.
May it please your Lordship. So there are two amendments before Lordship. The incident is of 1981. Just brief facts, and then I will come to the points. Won't take much time, please. According to prosecution, marriage took place with the deceased Ramkarari about 3 years back from the date of incident. That is 14th of July, 1981.
Date of incident, 14th July?
14th July, 1981. Time unknown. The FIR was registered
In July 91.
In 1981.
1981?
My lords, before the Section 304B was promulgated. And the FIR was lodged on the same day at 8:40 a.m. And the FIR was lodged by PW1, uncle of deceased, Chotelal. But may I just go? I have filed the extract of the paper book which was there, which was filed in the High Court. So as to, because all the statements are there. That is IA number 25503. Because in my SLP, only few statements were there, not the complete. So I'll be referring from that itself, unless of course you're also there. Now, in the FIR, 6 persons, 6 accused were nominated. The father-in-law Jagmohan, mother-in-law Ganga Devi, 3 brother-in-laws Chet, and the appellant number 2, Umesh, who was the husband. 9 prosecution witnesses were examined in all. 1 and 2, they are the persons, they have stated that there was some demand, and of course she was unable to get a child even after 3 years of marriage. Then PW3 is the chance witness that he was just passing by and he heard some commotion there. He has been disbelieved by the Honorable High Court.
Rajaram. PW3 Rajaram.
Rajaram. Yes, my lord. Then Dr. Rajan Shukla is he conducted the post-mortem where he found the first to 3 degree this thing, but no smell. That is important. No smell of kerosene oil or any other anti-mortem injury has been noted. Now PW5 is Bachal Singh. He also initially 161. He stated that he heard the commotion at night. He came down. Then this person was standing there. He has also not supported the prosecution case from examination chief itself. Then PW6 is the constable who took the dead body. PW7 is also Man Singh, who is a 161. He came up. He was also declared hostile. And PW8, Mohammed Saeed, is a hearsay witness. Then he was told about the commotion by PW3 members. The Rajaram, who has been believed. Then PW9 is Ram Jatan Singh, who has prepared the report. And PW10 is the most important witness, the investigating officer. Now, my lords, my submissions here, these 6 persons, I mean, the IU PW10 has admitted that besides these 6 named, all the mother-in-law and rest, all the adult male members, without any basis or allegations, they say they were involved. And FIR was lodged. In the FIR, there is absolutely nothing. So it's a case where there is not an iota of evidence of any circumstance to show that the chain of circumstances to prove that in fact they were involved. And my lords, they have been convicted with the aid of section 149, all of them. Now, 4 of the appellants, accused, Jagmohan, Ganga Devi, Ramesh and Mahesh, the father-in-law, mother-in-law and 2 Jade, they died during the pendency of the appeal. So now there are only 2 appellants before lodged. Now my very short submission is that my conviction which has been based by the trial court and the Honorable High Court is that my falsity of defense, and though it has come in evidence that the men folk were sleeping on the rooftop, they came down and their conduct was they did not abscond. Rather, the information was given by.
Has any of the accused received any burn injuries?
Others?
Has any of the accused received any burn injuries?
No, not at all. No.
Then if it happens in the same house, what efforts were made by you to save her?
The ladies who were sleeping downstairs, they put blanket, and in fact, even IU has recovered sari pieces in the veranda and all. That's all. And apart from it, so far as the 6 accused are concerned, because PW11 says that besides these 6, there are 5 other Jethanis and the daughter, another sister-in-law, and 5 small children. They all live in the same house. Now, my lord, I push a question to myself, solely on the basis of falsity of defense and relying on section 106, though there is absolutely no evidence whatsoever.
What does Trimukh say? What does Trimukh judgment say?
The High Court judgment.
Supreme Court.
My lord, I am relying on your lordship's judgment squarely covered by this, that unless you need an evidence that it was, the prosecution could not prove that it was either of homicidal death or it was distinctly came up with a case of accidental birth. Whatever, and therefore, circumstantial evidence, there is none.
No, but when the husband and wife live together.
No, we were not together. With due respect, my lords. This is not a case. If it is there, if my learned friend can point out, rather, they are absolutely silent because there is no other evidence except PW1, who is the uncle, PW2 is the father.
Uncle of the deceased.
Uncle of the deceased. And number 2 is the father of the deceased, who admits that she could not get a child for 3 years, whereas the Jethani had children. And their relations were, I will point out from that, if lordship so pleases, that husband used to visit, this Jade used to come to the house, and therefore, in order to, all the 6 persons, in prosecution of common object, there is absolutely no evidence at all.
Which one?
यही ना? I'm sorry.
Appellant?
One is the husband. One is the husband. Appellant number two, one is Jade, Suresh. Two is the husband. Now both of them are around 67 and 70, more than 70 years of age. And apart from it, except giving a suggestion to them that he fell down, though, although there is no.
Who put a plan? And that one. Found to be false regarding that kidney falling and.
This was only suggested in 313. We haven't taken this ground.
So in the defense also you.
Defense, my lords, may answer my one. This is precisely my argument. That the father has given a statement that 6 of them, except Lee, they were sleeping on the terrace. They came down, one of the boys doused the fire, and besides, unless the prosecution establishes that it's a case of homicidal or suicidal, it then, because solely on the basis of section 106, there is no, let my friend point out single circumstance except that the defense which I have taken is false or don't.
Yeah, and incident has taken place prior to 304 be coming into.
Yes, that's right. That's what I'm saying.
498 are
498
not there, and 30 incident of 98.
So, but then if it is a case under 302, then you will have to prove beyond reasonable doubt. Because if 304B is not there, and the approach which the High Court adopt, no, so therefore, that Major, I see your.
Initially, at the time of issuing notice, only issue notice actually to the consider bail.
Now the leave has been granted.
Always consider. Even if notice is issued for.
And they were responding.
Evidence Act.
They were arrested on 19th July.
Has come on 86.
Not 84. Yeah, 83, yes.
86. Our book shows it is come on November, 19th November 86.
The father has admitted that para 11, that all the accused persons were present in the house and the information was given by the father-in-law of co-accused Ramesh and his relative Nandakishore and which other person? Ram, this is that is just a minute. In the FIR itself, it is there that Ram Prakash and Nand Kishore. Ram Prakash is the father-in-law of one of the accused who died, Jait, and his cousin. They gave the information to these people. When they came and they went to lodge the report, then obviously, as an instinct of self-preservation, these people. Otherwise, they remain present throughout. It's not something that they acknowledge. And PW2 has admitted in para 11 that they were present. The information was sent because the village was 2 kilometers away of the first informant. They came, we were present, para 11, kindly see whether PW2, page 32 of the IABE which I have. Page 32, para 6 is also important. And then I will, para 6, 8. Before the death of Ramdul, has your lordship recorded my words? Yes. Page 32 of my IABE, which is the paper book, translated copy sent by the High Court. Before the death of Ramdulari, my son-in-law Umesh had visited my house. Ramdulari used to come to her maternal house. Umesh's brother's relations, Ramesh, had visited my house once or 2 times, but both these had come to take my daughter. Now 8. I don't remember who sent Ram Prakash and Nand Kishore to me regarding the death of daughter. Daughter Ram Prakash has been married, that is para 9, my lords. Ram Prakash has been married to Jagmohan's son, Ram Prakash, that is Ramesh, Samdi of Jagmohan. So one month immediately he lives there. The father-in-law sent us his Samdi and his cousin to inform the first informant. Everyone arrived in the morning, and then para 11. I did not complain in Biradri, Panchayat or any police regarding dowry matter, para 10. My daughter was educated, she could write a letter. I am not literate. Accused Suresh had
reading para?
And para 11 Manoj may have.
Yes.
When I reached at the spot, all the accused persons were present at the spot. Many villagers, so that should be villagers, were gathered. When we reached the spot, no police personnel was present at the spot. No altercation had occurred between the accused person and us. I did not say that the accused person, they had brought her to death. I doubted having seen the dead body that my daughter has been burned from TB, but she was burned. Baby was lying on the spot. And she was found on the Chabutra on a dolly where she was kept. Yes, I've read it. I'm also relying on that, don't worry. और कौन-कौन से स्टेटमेंट से सब दिखा दो. My lord's parents.
You see the approach of the High Court, come to page 17. The prosecution gathered the accused, having set the disease on fire, is therefore plausible and acceptable. What is the basic principle in criminal law? What is the basic principle in criminal law?